Good day, everyone, and welcome to today's SOFTRAX Executive Webcast. All lines will be in a listen-only mode for the duration of the conference. As a reminder, today's conference is being recorded. Now, for opening remarks and introductions, I would like to turn the conference over to Bob O'Connor, President and CEO of SOFTRAX Corporation. Please go ahead, sir.
Thank you very much, and welcome to the webcast, everyone. As you may know, SOFTRAX is the leading provider of revenue management solution to hundreds of companies, many of whom join us on the webcast today. We do have hundreds of registrants for this webcast, which indicates how much executives want to hear about today's topic from our distinguished speaker, Brian Pastuszenski of Goodwin Procter. And Brian will make his presentation entitled Taming the Risk and Liability Beast, Considerations for Senior Executives and Board Members. And Brian will be available for questions towards the last 10 or 15 minutes of this webcast after his prepared remarks. As you'd expect, we have many senior executives on the call today, CEOs, CFOs. We have board members, venture capitalists, VPs, and other corporate and financial professionals. So we're very excited about that. Let me just spend a few minutes talking about our agenda. I'll spend just a couple minutes talking about SOFTRAX and our revenue management applications and how they fit into today's presentation. And then I'll turn the webcast over to Brian for the majority of the webcast, where he'll talk about steps for reducing risk, protecting corporate decisions, designing and implementing compliance programs, what the SEC has for hot buttons, due diligence issues, and sustaining compliance. And for those of you who are unfamiliar with our webcast format, we leave about 10 or so minutes towards the top of the hour for you to ask questions, and all of this will be done by the top of the hour. And in order to ask us questions, what we'd like you to do is, if you look at your console now, and if you look for the Ask a Question button, you can then, at any time during the webcast, click on that, and I will be reviewing those questions throughout the webcast and ask these questions to Brian, as many as we possibly can, again, after his concluded remarks. The most commonly asked question is, can I get a copy of the slides? And I think Brian has about 40 slides, so you'll want copies of the slides. And the answer is yes, but we do make you work a little for those slides. If you look, there's a feedback questionnaire process that we'd like you to do. At the conclusion of the webcast, your browser will be automatically redirected to an online survey page. We read these. They direct our future webcasts, so we'd like you to complete that. And then once you do, that gets you the copy of the slides, and they will be directly downloadable. You'll also get a link for a rebroadcast, and you'll also get a paper that Brian and one of his partners wrote entitled Reducing Director Liability and Risk. So that's a lot of the housekeeping issues for this webcast. Just a few minutes on SOFTRAX. We provide application software that manages complex revenue processes, and we have customers who manage billions of dollars through our applications. U.S. and world, hundreds of companies in several different industries use our products to manage their revenue, their billing, revenue recognition, reporting, and forecasting. As many of you may know, SOFTRAX started by serving the needs of software companies and is the clear leader in that market. And as you can see, we have grown to address the complex revenue needs of many different industries. In a recent study, when it was discussed about internal controls and Sarbanes-Oxley, the question was asked, in your opinion, which area is the most difficult to establish internal controls? And not surprisingly to many of us and to Big Four accountants, that revenue recognition finished first as the area of the most difficult area to establish internal controls, followed closely by contract management administration, two areas where SOFTRAX solutions are targeted to help our customers. And in a very recent study, it was found that existing financial systems of both public and private companies are not managing revenue recognition processes and therefore providing a great deal of risks to senior executives and directors. In this study, 92% of public companies are still relying on spreadsheets and manual processes to manage their critical revenue transactions. CFOs of public and private companies do not lack for challenges in today's environment. They have operational challenges around their business model, and a lot of our customers have recurring business models, issues such as contracts and maintenance and subscriptions and transaction renewals, as well as compliance challenges, dealing with the SEC, which Brian will spend a lot of time on today, Sarbanes-Oxley, and many of these revenue recognition guidelines that you'll see in the center of your screen. And also, executives have reporting, visibility, and performance issues in efforts to be transparent and predictable in terms of their results. And our software solutions are closely aligned with these challenges and provide the following value propositions. We improve operational efficiencies and increase revenue. We enable complex revenue and expense accounting as our applications help from a compliance perspective. And we're helping from a strategic perspective to allow customers to get a better handle on their business performance and visibility. And our products are closely aligned with these three value propositions, as we have billing and operational suites of products that help with contract management, complex billing, contract renewals, subscription renewals, transaction-based billing, and so forth, and deep and unparalleled revenue recognition capability and paralleled expense accounting that goes along with revenue, and BI applications that handle visibility and strategic analysis of the business. And these products can be licensed as one suite or all together. And they are complemented by other applications that our customers use in addition to our revenue management applications. We are pleased that our customers report great improvement in compliance with Sarbanes-Oxley, with revenue recognition issues, greater efficiency in terms of issues related to revenue, whether they're revenue forecasting, revenue recognition, reporting, and so forth, and improved customer relationships as a result of using our software. And our mission is to help our customers comply with the ever-increasing regulatory requirements that we all live in today, while at the same time taking the opportunity to increase their revenue and reduce their operating costs as a result of that. So that concludes my prepared remarks, and as I said, this is all about Brian Pastuszenski of Goodwin Procter. As many of you know, Goodwin Procter is one of the leading law firms in the country, and has over 700 attorneys through that they serve from their offices in Boston, Los Angeles, New York, San Francisco, and Washington, D.C. And Brian Pastuszenski is back. He has done a webcast for us before, and back by popular demand, I might add. He is a partner in Goodwin Procter's corporate and litigation groups. He has achieved national prominence in the defense of securities class action and shareholder litigation matters and proceedings brought by the SEC and other regulatory organizations. His practice is concentrated in the areas of securities, class action, and shareholder litigation defense, defense of SEC proceedings, internal corporate investigations, corporate governance and compliance matters, M&A-related litigation, and other high-stakes business litigation. He has a long list of clients and accomplishments, and in the interest of time, I know Brian and the rest of us would rather just turn over to Brian and have him take it from here. Brian, welcome back, and the presentation is yours.
Thanks very much, Bob, and good afternoon to all of you on the phone. It's very good to be back. And as Bob said, this is more and something I think is very important. What I am going to cover over the next 40 minutes or so runs the gamut from issues that probably many of you are dealing with right now, extremely hot, extremely media-grabbing or headline-grabbing matters, and other issues that have a more enduring importance, issues that, frankly, go to the bedrock of what every company, large or small, ought to be paying attention to in terms of common sense, good corporate governance, and risk mitigation, risk avoidance considerations and practices. As Bob said, if you've got questions as we go along, able and answer them. So in terms of the topics, the place I thought I'd start is to give you a sense of what's going on right now in the litigation and liability landscape. We'll spend a few minutes looking at where we've been over the last few years, in particular the last 12 months, which has been a time, in certain respects, of a tremendous amount of change, tremendous amount of flux. I want to spend some time on executive comp issues with a particular focus on stock options, something that many of my clients probably never want to hear anything more about, but nonetheless very important and very timely. Related to executive comp, I want to spend some time on 10b5-1 plans, which I happen to be a major proponent of and what I view as a tremendous risk mitigation tool. I'm then going to shift to some issues that are of equal importance in the boardroom as well as in the management ranks, including diligence and corporate decision making, and then wrapping up my comments will be some discussion of indemnification, insurance, and personal liability. So let's start off looking at the landscape. Everybody who reads the papers knows that the last several years since Sarbanes-Oxley have been a time of extraordinary aggressiveness on the part of the government, both from the perspective of the SEC, which has responsibility for enforcing the civil securities laws, as well as the U.S. and state justice departments, which have the duty of enforcing the laws criminally. One unfortunate, from my perspective, consequence of the last few years is that much of what we see in the newspapers is being criminalized, is being prosecuted both criminally as well as civilly, and we can have a debate for hours, no doubt, on whether some of that prosecution is warranted and some of it not. But the point is, we have seen a tremendous period of aggressive, vigorous enforcement of the securities laws. At the same time, companies, I think, the vast majority of them, companies are trying to do the right thing. Managements and boards are struggling with the weight of regulation. And many smaller public companies, perhaps many of the companies who are dialed into this webcast today, have come to question the wisdom and the benefits of being a public company because of the burdens and the costs of compliance and regulation. Nonetheless, we still number in the several thousands companies that are listed on the various exchanges, despite the costs and despite the challenges. One of those challenges, unfortunately, continues to be securities class action and related shareholder litigations. This is something, as Bob said, that I spend much of my life as a professional dealing with. I defend these cases. More often than not, I win these cases, but from my client's perspective, I am a necessary evil because these cases continue to haunt the business community as they have for as many years as I've been in the business. One thing happened last year, however, that has made a number of people stand up and take notice. There was a roughly 36% decline in the number of securities class action lawsuits filed in this country. That is not an insignificant drop. It brings to mind the one-time drop in securities class action filings that occurred immediately after the passage of the securities litigation reforms at the end of 1995 over President Clinton's veto. And as you might expect, both lawyers on the defense side, like myself, lawyers who end up advising boards and management, and plaintiff lawyers and academics on the other side are scratching their heads and debating why the drop. Why did we see a materially smaller number of securities cases filed last year? The reasons are many, potentially. One reason that some people have advanced is better compliance by companies with Sarbanes-Oxley and related laws. Another reason that some people have suggested is that given where the markets have been moving, which is mostly sideways since the bursting of the bubble back in the 2000-2001 period, there are fewer IPOs and fewer targets for plaintiff lawyers to go after. That corresponds to lower market volatility, at least in the recent past. One not insignificant possible driver of the drop is the very public indictment of the Milberg Weiss firm and two of its very senior and very well-known partners. This is a factor, I think, that is not to be underestimated, though my crystal ball is no better than yours in terms of what accounts for the drop. But historically, over the last several years, Milberg Weiss has filed more than 50%, pushing 55% of all the securities class action cases brought in this country. It has seen a bloodletting, so to speak, over the last several months. Senior lawyers, junior lawyers have decided to take their futures elsewhere, have joined competing firms. The firm is still in existence, but it is a perhaps if I say fraction of its former size, that would be an exaggeration, but it is substantially winnowed down from what it used to be. And time will only tell if that is the driver of the statistic or if there are other reasons. But one thing that I would say to you, however, even though my crystal ball is not perfectly clear, is that this is not a time to take a step back and breathe a sigh of relief. For every lawyer that leaves Milberg Weiss, a lawyer joins another that does the same thing. And just like insurance, you've heard the saying that insurance abhors a vacuum. The same thing is true of plaintiffs' securities class action lawyers. They abhor a vacuum. And the fact created by Milberg Weiss troubles is I can assure you, being taken up by other firms as immediately as that slack appears. In addition to the drop-off in securities cases nationally, what we're seeing is an interesting and somewhat ironic development. The number of smaller settlements, which I like to consider nuisance settlements below $3 million, and that shows you how distorted things have got when a $3 million settlement can be considered a nuisance settlement. The number of settlements at $3 million and under has declined appreciably. At the same time, the number of large settlements has increased, so that what we've seen since the middle of 2005, so just about years, is that the average settlement has risen 31% to almost $35 million. Now, that number does not include, and this is an important fact, does not include the mega settlements. And there have been a number of them in the last a few years, mega settlements above $100 million. That $35 million figure, $34 million figure, does not include averaging of the huge settlements. If you include the huge settlements, like the WorldCom and Enron settlements, you get a substantially larger number. I've done that. I've factored those out so as not to unfairly skew that figure. So that's a very significant number. And if you're a public company in these markets, the chance of getting sued in a securities case is not insignificant. And the average settlement at $34 million is nothing to sneeze at, which is why I intend to spend some time at the conclusion of my remarks talking about D&O insurance and indemnification. It probably won't surprise you that the settlement amount you're likely to see in a case will be higher if you're being accused of accounting irregularities, particularly an accounting restatement, a financial restatement, or other kinds of irregularities, revenue recognition, earnings misstatements. If you've got those kinds of allegations in the lawsuit that's been filed against you, more often than not, if it settles and doesn't get thrown out, and by the way, when these cases get filed, my modus operandi is to try to get them thrown out because, in my experience, the vast majority are not well taken and are not based on merits. But if it does survive and does ultimately settle, the settlement is likely to be higher where there are accounting regulations, where there was an IPO or public offering involved, or where you've got company and your public auditing firm or an investment bank is standing next to you as a co-defendant. That will also drive the amount of the settlement up. Now, one silver lining, I think, in this picture is that the securities law reforms that I mentioned a few minutes ago that were passed back over Clinton's veto in 1995 have been having some beneficial impact for my clients and other companies in the business community. As a result of the laws becoming tougher for plaintiffs to comply with, the number of cases that have been thrown out as lacking legal merit right at the outset before they ever get into discovery has nearly doubled in the last 10 to 11 years. And so that if you look at the time period 1999 to 2004, which is the period for which I've got the most recent statistics, almost 40% of the securities cases filed in this country have been thrown out. And that is, to me, somebody that is a defense lawyer and does this for a living, that's a very gratifying figure. At the same time, we've seen, not surprisingly, given all the attention on revenue recognition, the attention on option accounting, we've seen a huge increase in the number of cases alleging some kind of accounting irregularity. Over 50% increase last year, that is to say in calendar 06, in cases alleging accounting violations, and many of those are options related. Almost 40% of the cases now being filed allege some kind of trading by insiders on the basis of material non-public information, directors and officers. And the reason for that is not surprising. If you're a plaintiff lawyer and you're alleging fraud, you want to be able to tell a very compelling story of fraud to the judge, so the judge thinks twice before he or she grants my motion to have that case thrown out. Let me shift away from the liability landscape to something that, as I said at the beginning, is probably near and dear to the hearts of many of you on the phone, and I know many of the companies that I have the pleasure of working with, and that is executive compensation and specifically stock option related issues.
And Brian, as you do that, I just want to remind the audience, if they have any questions for Brian that you'd like to have answered at the end of his prepared remarks, to please click on the Ask a Question button on your console and type it in. I'll continue to read them as Brian continues to do this, and we'll ask the questions in about a half hour or so. Sorry to interrupt, Brian. Please continue.
No, that's my pleasure, Bob. Thank you for doing that. So I want to spend some time on stock option issues, and I'm not going to bore you with things you already know, but there are some important developments, and I think some important considerations for all of us to be thinking about. Executive comp, at least one aspect of it, is the ability at the appropriate time to be able to get liquidity and to be able to sell stock or exercise options and then sell stock. And in that regard, I want to spend some time talking about something that I think is what is becoming increasingly popular and increasingly used, but is still, I think, an underappreciated liability mitigation device, and that is the Rule 10b5-1 trading plan. So I want to spend some time on that. Stock options. A day does not go by that you can't pick up the Wall Street Journal or the Boston Globe or the LA Times and read an article about the latest company that has been embroiled in an options-related matter, whether an SEC investigation, a lawsuit, or an announcement that the company has delayed earnings in order to continue and complete an internal investigation. This began over a year ago. It continues to roll along, and a number of academics, law school professors, professors of econometrics at various universities across the country have jumped into the fray and probably in no small part are contributing to this continuing to be a matter of attention in the media and a matter of attention for the regulators. There are many, many companies that are dealing with this. Over 200 public companies have announced regulatory inquiries or investigations of some sort. When a company announces some kind of options-related problem, there seems to be almost as a foregone conclusion that there will be some kind of shareholder litigation filed. Now, I would say relatively few securities class action cases and relatively many shareholder derivative cases, cases brought ostensibly in the name of the company for harms allegedly caused to the company. And I think the reason for that is not too hard to figure out. If you look at most of the companies that have announced some kind of option-related issues, their stock prices have not, for the most part, there are always exceptions, but for the most part have not moved materially. And that may be due to the fact that option-related issues are non-cash. They are non-operations related. They certainly involve important accounting issues. But it appears that investors in the market as a whole have largely viewed the option-related problems, not affecting the fundamental viability of the business. And that, of course, is to say where you've got problems that don't involve a complete overhaul of management or issues that really cause the viability of the company to be put into question. When litigation is filed, the lawsuits in all sorts of claims, but probably among the more common, are that if you've got options that have been backdated, that is to say, where the allegation is that the company or the board or management has picked a date for the grant that actually predates the actual date on which the grant occurred, thereby giving the grantees a lower price than they should have gotten. When those options are exercised, the company is actually getting paid less than it would have gotten paid had the grant date been measured appropriately. That's one flavor of claim. Another flavor of allegation, of course, is that by backdating or by misdating the options, the companies have understated compensation charges, which conversely have overstated earnings. And those are the claims you see in both the securities cases as well as in the shareholder derivative cases. As a matter of full disclosure, I will tell you that I have spent a not insubstantial portion of the last year working with audit committees, representing special board committees, representing officers and directors and companies in a variety of stock option-related investigations, lawsuits, internal reviews across the country for companies based from the West Coast to the East Coast to the South. And I can tell you that in many, many, many cases, the issues involve good faith administrative glitches, timing issues that have arisen for a variety of reasons, some of which may include the fact that for certain grantees who were awarded options, the amount perhaps wasn't completely finalized at the time of the grant, or where there may have been some changes in the list of grantees after the grant date because some people might have been inadvertently omitted. We see many situations where there are, honest-to-God, accounting issues, but they result from inadvertence or, as I said, administrative glitches. There are certainly cases that have hit the headlines where, from all indications, there was intentional backdating of grants, where new hires were given grant dates that actually predated when they hit the payroll. We've also seen situations, again, in the papers and in the various regulatory matters that have been announced, where companies have been accused of timing grants either to immediately precede the issuance of positive corporate news or to come immediately after the announcement of negative news. In the former case, the value of the options arguably rising. In the latter case, the value of the options being enhanced as a result of being granted at a time when the stock prices dipped because of negative corporate news. Many of you may be aware of this, but there is not complete agreement, even within the SEC, regarding whether this practice of spring-loading or bullet dodging are the terms that have been coined to describe these two kinds of timing issues. There's disagreement even within the SEC as to whether these practices are illegal. SEC Commissioner Atkins very publicly last summer made statements to the effect that in his view, and of course he's only one of 5 commissioners, in his view, these practices were not a violation of the securities laws. I will tell you, however, that in the last few weeks, and I'm going to spend some time talking about this in a minute, in the last few weeks, the Delaware courts, specifically Chancellor Chandler of the Delaware Chancery Court, has issued 2 opinions that have, as a matter of state fiduciary duty law, taken the position that backdating and spring-loading are, if proved, if proved, would constitute violations of a director's fiduciary duties. Let me spend some time on that because many of you may be getting updates by email or in the mail from law firms describing these cases. Perhaps you've gotten an update from our firm, my firm, Goodwin Procter, on this. They are the two of the first decisions relating to stock option practices to come down in the wake of everything we've been reading for the last several months, almost a year now. It is important as I describe these cases, and I'm only going to describe them very briefly to you today because this isn't a place to get into a long legal discussion. But what's important to remember is that these cases involved preliminary procedural rulings by the court. These are not determinations that any of the directors or any of the managers involved violated the law in fact. These are simply determinations that the plaintiffs in their complaints have alleged enough to entitle them to, take the next step in the lawsuit. So with that context in mind, there are a couple of cases, one involving the Tyson companies and one involving the Maxim company, which is in the high-tech business. Each case involved allegations of option misconduct. In the Tyson case, we had an allegation that the board was intentionally spring-loading grants, that is to say, issuing grants immediately prior to the announcement of positive corporate news, thereby causing the price to go up and enhancing the value of the options for the grantees. And on the screen, you will see a quote from the case where, assuming for purposes of the court's decision, the truth of what was in the complaint, mind you, the court said, in essence, that a director who uses inside knowledge, which the market doesn't know, in order to enrich employees, while at the same time issuing options in violation of a plan that says the options have to be issued at fair market value, cannot be said to be acting loyally and in good faith. And if you cut through that legal verbiage, what it means is if the plaintiffs prove that the board knowingly spring-loaded the grants in this case, there could potentially be liability. Assuming, and there's a big assumption here, obviously, because we don't know what the facts will show, but assuming that in a case the plaintiffs could prove that there could be potential implications if a court were ultimately to find after trial that the directors of a company had not acted in good faith, had been disloyal as a matter of proof and fact, that could have implications for whether those directors would be entitled to indemnification from the company or entitled to insurance. So this is not an insignificant ruling, but again, it's a very preliminary one, and it is not the result of anyone having gone through a trial. And I would remind everyone that one case I'm going to spend a couple of minutes talking about is the Disney case, and ultimately that case went all the way up to the Delaware Supreme Court, and the Disney directors were found not to have violated any law. But that case went on for, I believe, almost 9 or 10 years, and everyone said everything that you could imagine about what might befall those directors before the ultimate curtain closed. So, again, a preliminary ruling, and it's important not to read too much into it. The Maxim case involved a different type of alleged option practice. This was backdating. So, allegedly, the defendants had deliberately gone back in time to pick a lower price for the grants than the price in effect in the market on the date of the grant. And the court said something very similar, that if such conduct could be proved, that would not meet the test of the business judgment rule, that would not be entitled to deference from the court, and there could be a substantial likelihood of director liability. So these cases have, I would say, shot a cannonball across the bow in the legal community. Lawyers like myself are reading these cases and trying to understand what they mean and their implications. But you should be aware that the first couple of cases, or among the first few cases to be filed, have now been allowed, at least for the moment, to proceed to the next step. let me spend some time, just a brief amount of time, on a related development. Under Delaware law and the law of other states, it is possible, even before filing a lawsuit, for a plaintiff's lawyer to try to get access to your corporation's books and records, what would otherwise be confidential books and records, provided that the plaintiff is a shareholder and meets certain requirements for having a valid purpose for seeking the records. We are now seeing, in fact, I have a matter for a client right now that is pending in the Delaware courts, where plaintiff lawyers are seeking to get access to internal corporate records relating to option grant practices, executive and board compensation, and related matters in order to determine if there's a basis to file a shareholder lawsuit. Whether or not these cases are based on good arguments for such inspections or not is something that the courts are going to have to decide. But looking into my crystal ball, I would expect we're going to see more of these kinds of proceedings under Delaware comparable law in other states. So I want to leave the stock option area with just a couple of considerations for you as senior management and directors to consider around the options area. Number one, as you're deciding, as you're looking forward to what the company's option practices and procedures ought to be in the future, consider using a fixed grant date, either annually or some other regular period on which the grants will occur. If they occur on the same time each year, it's much harder for those grants, hindsight, to be challenged as having had their timing manipulated. Secondly, consider granting earnings or granting options immediately after the announcement of quarterly earnings, at a time when the market essentially has the same information that the company does. The reason for this is it makes a challenge based on spring loading that much harder to make, and it's a much less risky time to grant options than it might otherwise be. Again, there are a variety of things companies can do, but this is a consideration that I suggest to you. Another option is for companies that, for all practical purposes, have had effective delegation of granting authorities to management, but where it has not actually been reduced to writing. Now would be an excellent time, if management has been given that authority de facto, to make it formal and put it in writing so there's no question that management has the ability for certain types of employees and up to certain grant levels to grant options without having to run through comp committee approval. Consider having grants that are approved by the comp committee approved at minuted meetings, where you've got a record that the committee met on a certain day at a certain time and took a certain action, where attached to the minutes can be a list of the grantees and the grant amounts. It, again, removes many, if not all, of the questions around the option grant issue that we are all facing now and presumably will continue to face for quite some time. And then the last issue I leave you with is really a question. As companies, whether they're companies I work with or companies that other lawyers work with, if accounting problems are detected, I think boards and special committees and audit committees are faced with a very, very difficult choice, particularly in cases where there is no evidence of any sort of deliberate intent to misstate financials or any sort of deliberate attempt to violate accounting rules or violate legal rules, where the practices have not been intentional. It is the best thing for shareholders and for the corporation. While it may be easy in some senses for the special committee or the audit committee to pull out the gun and aim it at management that was in place during the period of time, I leave you with the question of whether that at the end of the day is ultimately in the best interest of the shareholder base and ultimately in the best interest of the corporation. Let me shift now to something, as I said at the beginning, is a favorite topic of mine. I've talked about this, I believe, in this forum before. I've talked about this in boardrooms and ballrooms across the country, and that is Rule 10b-5-1. Rule 10b-5-1, in a nutshell, gives you as a corporate officer or director the ability to sell or buy stock at a time when you might not otherwise be able to because you're aware of material non-public information. The keys to the kingdom is that you create and set up a trading plan or a trading arrangement that provides for the sale or purchase of stock automatically, or you can give discretion over that to a third party like a trustee or a broker or an advisor. But you must set one of these plans up at a time when you're not aware of material non-public information. If you set one of these plans or arrangements up right, however, you have the ability to get liquidity, sell stock at a time when your insider trading plan or federal law may otherwise prohibit you from doing that. And if you're a company that's very acquisitive, if you're a company that has a volatile stock price where something's always going on within the company, that is to say of a good nature, important developments, important R&D developments, important clinical trials, if you're in the biotech area, you may find that you're never able to sell stock. And what the 10b-5-1 mechanism permits you to do is to sell stock at a time when you might not otherwise be able to. For corporations, it also has a feature that facilitates the corporation's ability to do open market repurchases of shares at a time when otherwise it might not be possible because the corporation is aware of public information. And it can also be used not only for stock sales and purchases, but also for option exercises, which in the current environment is something that I think a lot of us would consider a fairly important consideration. If you're going to do one of these plans, however, I strongly encourage you, even though in certain situations it's not necessary, strongly encourage you to put it in writing. I strongly encourage you to have what I refer to as a burn-in period, which is a period of time after you enter into the plan where the first trade actually takes place, 30, 60, 90 days. The longer the period of time, the better you are, and the reason for this is, again, you must set it up at a time when you're not aware of material non-public information. The longer the first trade happens after you set it up, the less likely that any information in your head is likely to be material or, frankly, likely to even be relevant anymore. And the best time, from my perspective, to set one of these things up is right after your company releases earnings. Not surprisingly, I recommend that once you set one up, even though you can terminate at any time, you're not locked into these things. It's not like a shackle around your ankle. But I don't recommend that you repeatedly start it, stop it, start it, stop it, or repeatedly modify it, because the more you do that, the more attention you're going to draw to the plan from a regulator, from a plaintiff's lawyer, from somebody whose attention you probably don't want. A couple of other things on these plans. As a defense lawyer, as a lawyer who is hired day in and day out to defend securities cases and shareholder cases, one of the things that you can do for me that helps me do my job better and more effectively for you is when you adopt the 10b-5-1 plan to disclose it. Don't necessarily have to disclose all the details of it, but announce it to the world in an 8K or some other kind of filing, as when that plaintiff's lawyer alleges that your trade was on the basis of material non-public information and violated the securities laws, what I then have the ability to do is point the court to that public filing, that evidence that you did that trade under a plan that was put in place 18 months ago, and allege that you trade on inside information is frivolous and not made in good faith. That makes me that much more likely to get that case thrown out or substantially truncated than I might otherwise be able to do. The last point I want to make, and again it goes back to this concept of don't do things with your 10b-5-1 plan that are going to draw attention to it. At least one SEC lawyer, the one I'm thinking of, was a regional SEC administrator out in the Midwest, who within the last year made the comment that he had become concerned that companies were using 10b-5-1 plans in a manipulative way, that they were holding back on the release of important corporate news, negative news, in order to enable officers and directors to get their trades done under plans before the bad news hit. And this particular lawyer suggested that that could be by itself fraud and a manipulation. And I mention it because that's something that we should all make sure we never be accused of. The next to last topic that I want to cover is, I would say, diligence and compliance. Enron and WorldCom are hopefully fading into the distant past. But one important aspect of particularly the WorldCom case is that it involved the public offering of securities. And when you offer securities to the public, there is strict liability, meaning as long as there is a misstatement and it's material, there's potential liability for the issuer. If you're a director, however, have what's called the due diligence defense. You can point to the fact that you asked questions, that you were diligent, that you did an appropriate investigation, that you discovered no problems, and therefore you should have no liability. The takeaway of WorldCom that I want to remind you about, and that I remind audiences like you about all the time, that diligence means diligence. It means something other than blindly relying on what, if you're a director, management has said, and in the case of financial statements that haven't been audited, on what the auditors seem to be saying. My recommendation to you here is create a record in the context of a public offering that you've asked questions, that you've been diligent, that you've done more than passively rely. And if you do that, and if there is a problem ever that arises after that offering, you will have put yourself to a much better position from a liability standpoint than you would otherwise be in. You don't need to redo the auditor's audit. That's what auditors get paid for. But I strongly recommend you record of good and active questioning. My next slide, stocks for private companies. All I'm going to say on this, that private companies are increasingly being looked to in the same way that public companies are to make reps and warranties in the context of M&A transactions. And if you're a director of a private company looking to do an M&A or financing transaction, the earlier that you realize that you may be asked to make reps and warranties like a public company, if you do a deal with a public company, the sooner you can put goals and the processes in place that you're going to need to in order to make those reps and warranties. My last two topics are corporate decision-making and insurance and indemnification. I can wrap everything in these slides around decision-making into the following couple of words: good faith and diligence. Good faith is essentially where Delaware law has come out as a result of the 10-year-long litigation in Disney. The court there said that under Delaware law, which is pretty much the bellwether for fiduciary duty law in this country, a director who acts in good faith and makes a good faith effort to inform him or herself of the important facts relevant to a corporate decision will be protected from liability. And that is ultimately the takeaway of Disney. It is also the takeaway of another case mentioned in my slides later on, the Stone v. Ritter case, a very recent Delaware case involving an accusation that a board of directors had not done an appropriate job putting an effective compliance program in place. This company ended up spending $50 million in fines and penalties because its employees anti-money laundering and suspicious activity rules. At the end of the day, those directors did not have liability. And the reason the court said was because there was evidence that they'd acted in good faith, and the court said the only time a director will have liability in connection with a compliance program is where either there's been a complete and utter failure to even attempt to put one in place, or secondly, you got one in place and you completely ignore it. And that's a very high hurdle for a plaintiff, but that's not to say that we as directors and officers ought to sit back and assume that we don't have exposure, because there is exposure. But again, if you create a record of diligence and you use care and just a little amount of caution and foresight, there is a tremendous amount of protection under Delaware law that will be available for you. And the last thing I want to say, and then I'm going to end my remarks, is to flip to the slides dealing with insurance and indemnification.
You can take a minute or two on that, Brian, if you like. Go ahead.
This is obviously an extremely important topic because it hits all of us personally. Insurance, indemnification, and personal liability. Insurance is something that fundamentally is a legal contract. And I strongly recommend, in fact, here at Goodwin Procter, we have an insurance group that does nothing other than help public companies, private companies, venture capital funds, private equity funds, better manage their risk exposure. And part of what we do is we help put insurance in place and help negotiate insurance policies, which are effectively contracts. As the market improves, I saw that the Dow was up to 12,000 something. As market caps increase, the need to make sure that all of our companies have adequate insurance in place is extremely important. And I strongly recommend that you consult with an expert. Doesn't have to be my firm, though we'd be very happy to help, but with an expert that can walk you through what you have, where it may be adequate, where it may not be so adequate, and where you might be able to improve it. And I will tell you, for those of you who are members of management, and you've probably already seen this from your own boards, directors, independent directors, have become extremely interested in the kinds of coverage, not only in the dollar amount, but the features. It's a very, very savvy group of individuals, and they're asking some pretty tough questions of management, so another reason to really look closely at what you have and whether it's the best for, bang for the buck. Indemnification is another topic that senior management and directors are well advised to pay attention to. Corporate bylaws and corporate charters all provide indemnification of some sort or another, but many of them don't dot the I's and cross the T's in as friendly and as favorable a way as indemnification agreements do. I'm finding an increasingly large number of the directors that I represent want to have standalone indemnification agreements to deal with some of the issues like how quickly my lawyers' legal bills get paid when there's a problem, issues that aren't dealt with in many cases by bylaws and charters, and this is an extremely important thing to pay attention to. One thing that I would recommend all of you do, if you don't already have it, is think about whether you should have in your charter what's called an exculpation provision, which essentially is a provision that says in the event of a lawsuit, your directors cannot be held liable for basically good faith screw-ups. Many companies have them, but many companies don't have them, and the ones that don't, I at least think you want to be thinking about that. And last but not least, I want to leave you with this thought. We have a very risky world that we have the benefit or the pleasure of dealing with. It's gotten riskier since Sarbanes-Oxley. It's gotten riskier in the last 10 years since securities reforms were put in place. And despite the 36% drop-off in securities class action filings, this particular cynical defense lawyer thinks that that's a temporary blip. But this is not a reason to panic, and it's not a reason to despair, because with a little amount or maybe a moderate amount of care and time and diligence, you can protect yourself in a very meaningful way. And hopefully, if I've communicated anything to you today, I've left you with a couple of things, not necessarily silver bullets, but at least a couple of considerations that are worth some thought. And I'm happy after the webcast in the weeks and months to come, if any of you have any questions, to you'd like. And I thank you, Bob, and thank you, audience, for the opportunity to talk.
Great, Brian. Thank you very much. A few minutes for just a few questions. Brian, we had a lot of questions around management turnover as a result of this. Obviously there have been high-profile cases where management has left, and there have been other high-profile cases where management has stayed. And I think some people on our webcast wonders, what's the defining element there in terms of whether they stay or go? Is it intent? Is it good faith? You mentioned a lot of this is just good faith. Administrative glitches is the term you used. I assume in those cases they stay, but maybe if you could help give some kind of high-level guidelines about what you see in terms of whether management is leaving or staying when caught in when these kind of situations arise.
The answer is yes, yes, and yes.
Usually lawyers say the opposite. So that's
well, no, I think the honest answer to your question, Bob, is that inadvertence and good faith is part of it. But like most things in life, it so depends on the particular facts that you have in front of you. I have spent many late nights with directors deciding what to do with the information that's come out during the course of an investigation, whether it's information in emails, information in documents, information that's come out of interviews, and it is, I would say, more often than not clear, and frankly, directors who are tasked with having to make sense out of it all do not have an easy time of it. So yes, good faith and inadvertence enters into the mix, but frankly, it's also partly, I think, the perspective of what is going to be ultimately best for the company. That is something that directors struggle with, and in many cases, it also happens to be, who are the professionals advising the committee that's doing the investigation. Some, I think, take a different approach than others do. And certainly, there's a perspective that if the most conservative approach is taken, that may be the safest. But again, I think that the truth lies in the fact that these cases turn on really the specific facts, and there are some very, very difficult decisions that I know a lot of directors who I highly respect have spent hours and hours and hours struggling with as they reach their determinations.
And I kind of follow up that, again, more questions about this because we had a lot of questions about this. In that situation, do you see the directors mostly saying making the decision, or more likely is it the management team saying before the directors get there that I should move on for the good of the company? And again, is that a yes, yes?
I think it's, again, a yes, yes. I think sometimes, depending on what the documents show, sometimes management decides to move on for the better of the company. Other times, where there have been management level changes, it's the result of a oftentimes months-long process of sifting through all the information, and the board having to make some tough calls, or the committee, whatever the body is that's been entrusted with forming some conclusions based on all the factual information that's come out. So you were right. It's yes, yes.
Very specific question here. Given the importance of Delaware as a state for major corporate incorporation, aren't the rulings of the Chancery Court there on spring loading and bullet dodging likely to carry major weight with other legal jurisdictions?
The answer to the question, I think, fundamentally is Delaware is an important jurisdiction. It's where most companies in this country are incorporated, and yes, the courts of other states look to what Delaware does as a barometer. So I would agree that judges in cases in other states are going to be looking to these rulings. But again, at the end of the day, everything turns on the facts, and what's alleged in these complaints may be very different from what ultimately is proved at trial, which was precisely what happened in the Disney case. If you read the complaint in the Disney case, many people thought that the Disney board ought to be taken out and with field and shot. At the end of the day, after trial, very different set of facts got proved than what had been alleged.
Brian, last question. You said your crystal ball is no better than ours. I'm, for one, thinking it probably is better than ours, but I'll leave it as what you said. We had a bunch of questions about, what do you think the future brings. We had some questions about when Sarbanes-Oxley was, as a result of corporate governance, was taking hold, as a solution to the situation that we were then in. Some people talked about, is a stock option bigger than that? Is it much ado about nothing, given that, as you said, the stock prices are frequently unaffected? Some people ask questions about where all this is headed over the next few years, and maybe if you can comment with respect to the Sarbanes-Oxley legislation and compare it to what might be ahead in the stock options.
Let me say about the stock options, Bob, that what the market does is one thing. There's no question that companies have an obligation to accurately report revenues and earnings, and fundamentally, whether a company has an accounting problem because of an administrative glitch or a company has an accounting problem because of something else, in order for the public markets to work in this country the way they're supposed to work, that presumes accurate financial reporting. But if you look at what's happened in the vast majority of cases, I think investors in the market have not viewed the options issues. They certainly haven't viewed them with a reaction that's produced, in most cases, significant drops in stock prices upon the announcement of option-related issues. Looking forward into the future, in terms of Sarbanes-Oxley and related issues, I think we've got currently a chairman of the SEC who is attempting to look at the regulatory framework in place now, and that's been in place since 2002, and trying to evaluate and assess whether, as currently written, it is working and it is sensible. And I think there's a willingness on the part of the current administration within the SEC to reflect on that and step back and see whether it might not be appropriate for certain changes. I mean, that's certainly something I think that the current chair of the SEC has made clear. I don't know what will befall the business community after the current options situation has been resolved. We've seen over the last several years a spate of revenue recognition restatements. We've seen options in the mutual fund context. We've seen the market timing phenomenon and all those lawsuits. Knowing what my crystal ball has shown me over the last 25 years, there will no doubt be something else. I can't predict what it is today, but I have, I guess, some abiding hope that the business community will be able to work through it, and that at the end of the day, as I think has been the case after each one of these phenomena before, it will fundamentally be stronger, and we will all have learned. But you're right, my crystal ball is pretty cloudy, and I think that's about as much clarity as I can give you.
All right, great. Well, thank you very much, Brian. Thank you for your insightful comments. I know I learned a lot. I'm sure our audience also learned a lot as well. And thank you for the audience for your attention, your participation, and your questions. I'm sorry we couldn't get to all of them. And please continue to look at our websites, SOFTRAX.com and RevenueRecognition.com for future events. And I will remind you again that we're looking forward to your feedback. If you'd like copies of the slides and Brian's article, look now at your browser will be automatically redirected to an online survey page. We want your input, and that'll allow you to get copies of Brian's slides. And again, thank you very much, Brian, and thank you, everyone, for participating. Bye-bye.
Thank you, Bob.